Let's go ahead and start. Let's put phones away. Raise your hand if you turned in a paper in both formats. Raise your hand if you have turned in a paper in one format but not the other. All right, get us the other format, please. If you have not turned in a paper at all, then obviously come see me and let me know what's up. If you've turned it in one format but not the other, you will not get a grade on it until you give it to us in both formats, so make sure you do that. Usually with these last papers, my goal is to hand them back at the final exam, given our early exam slot. I don't know if we'll be able to do that. We will do our best. The exam is Thursday of next week at 8 a.m. in this room. I have no control over the day or the time. I got to be here too. So Thursday of next week at 8 a.m. in this room. So with the paper behind you, right, the exam is what we got left, basically. So it's not that much time between now and then, but let's try to finish strong and do well on that exam. And so today and Thursday, we're still talking about new material, so obviously read and keep up with that material. Today we're talking about religious freedom, and Thursday we're talking about gun rights. And on Tuesday of next week, the topic listed on our syllabus is the Constitution in Trump's America, and there is only a really brief reading. There's nothing really in the textbook about Donald Trump because the textbook came out before Donald Trump was elected. But there's a few pages of some kind of introductory material on the kind of contemporary era that I thought were somewhat relevant. And it says further readings to be determined. I don't think I'm going to give any further readings just since we're so close to the exam. But I do want to use that last day. We can use it in part as exam review. People have questions about material relevant to the exam. And I want to use it part to have a little bit of an open-ended discussion about, based on what we've learned so far in this class and Kama 1 for many of you, what do we think about how our Constitution is operating in the current political era. So that will be the goal for next Tuesday. Also on Tuesday, a week from today, your attendance and participation self-assessments are due. So make sure you give me those. They are, if you took Comma 1, you did one of these already, so you know what it's supposed to look like. If you did not take Comma 1, or if you don't remember, make sure to look in the syllabus. It's in here somewhere. There's a detailed set of instructions on page, my page numbers are cut off on the syllabus, so I don't know what page that is, but under course assignments and then under attendance and participation, there are detailed instructions for writing the attendance and participation self-assessment. The gist of it is to assign yourself a letter grade for class attendance and participation, and then to write a couple paragraphs explaining and justifying that letter grade that you have assigned yourself. And in the instructions in the syllabus, there's some specific things, instructions of what you should address in that self-assessment. So I found these to be helpful in the past. I encourage you to you could write it in 5 minutes, right before class, because you just remembered. I encourage you to spend a little more time than that on it. It's not supposed to be like an onerous additional assignment. It should not take you hours to do. But you should read the instructions carefully and attempt to address each of the things that are mentioned in the instructions, because those are things that I am interested in thinking about as I assign everyone a grade for attendance and participation. Okay, so papers, give me both formats if you haven't done it already. Self-assessment due a week from today. Exam is 2 days after that. I encourage you to study between now and then. I encourage you to study collectively. I encourage you to use the handouts as a study guide. If there is substantial portions of the course material that you are not closely familiar with because there was some portion of the semester that you kind of missed in some way, then I encourage you to go back and learn that material as best you can. I encourage you to review what we've covered. I encourage you to talk about it with friends in the class, and get a good night's sleep Wednesday night and come in on Thursday of next week ready for the exam. Any questions about any of those logistical things? Okay. Religious freedom today, which we started talking about last week. Oh, and so tomorrow, the Supreme Court in Washington, D.C., its last day of oral arguments for the current term is tomorrow. The court's annual term runs from the first Monday in October till roughly the end of June, and roughly around now, in early April, or late April, where are we? In late April, the court stops hearing arguments in new and additional cases, because their goal is to fully decide and resolve and write the opinions in all of the cases that they've heard by the end of the term at the end of June. Very occasionally they say, oh, this case we weren't able to resolve in some way and we're going to work on that one again next year. But that's unusual in general. They try to, every case that they've heard, they try to decide by the end of the term, and so they have to stop hearing new cases, right? So they have time to resolve all of these cases over the coming weeks by the end of June. So tomorrow's the last day that they're hearing arguments in a new case, and tomorrow they are hearing arguments in President Donald Trump versus State of Hawaii, which is a case about President Trump's immigration ban, executive order. The third version of President Trump's immigration ban executive order. The case is partly about immigration law, obviously, and it is also partly about religious freedom. So as you may recall, during his first days in office, President Trump issued an executive order that banned basically all immigration, almost all immigration from 7 majority Muslim countries. It named 7 countries, all of which were majority Muslim countries, and it said there can be no immigration from those countries except that religious minorities in those countries may be subject to a waiver. So, and they're all Muslim majority countries, right? So the religious minorities in those countries are non-Muslims, and Trump himself said publicly, oh yeah, the goal of this is to still allow some Christian immigrants from those countries, but to block Muslim immigration, to block most of the world's Muslims from immigrating to the United States. That version was struck down in court. Trump issued a second version of the executive order, which dropped one of the 7 countries. It dropped Iraq from the list. Retained the other 6 Muslim majority countries, retained the ban for those, but dropped the provision saying that there could be exceptions for religious minorities. So it's still, the second version still banned most of the world's Muslims from immigrating to the United States, but was less blatantly discriminatory because it no longer said that Christians from those same countries could still come. That one was struck down in court too. And then last fall, President Trump issued a third version. I think it was September, somewhere around there, last fall. He issued a third version that makes no reference to religion whatsoever, and added 2 additional countries to the list, which are not Muslim majority countries, right? It added Venezuela and North Korea to the list, although if you read the order closely, the rules that apply to immigration from Venezuela and North Korea are not the same as the rules that apply to the other 6 countries on the list. But there are some non-Muslim majority countries on the list now that some immigration restrictions would now apply to. And purportedly, the justification for banning most immigration from these countries is entirely related to national security threats and has nothing to do with immigration. And Trump himself has stopped making public comments, which during the debates over both the first and second versions, Trump was repeatedly making public comments saying that the goal of this was to stop Muslims from immigrating to the United States. He had stopped saying things like this, and the order itself does not say anything like that. The order itself says, for national security reasons, the following categories of immigrants are not allowed to enter the United States from the following list of countries, most of which are Muslim majority countries, but not all of them. And so one of the arguments in this case for the Supreme Court tomorrow is whether this still violates the First Amendment by unconstitutionally singling out for disfavored treatment members of a particular religion. The order itself does not really say that, but there is some substantial amount of evidence that the purpose of the order, the reason that this series of executive orders was issued by our government, was to ban adherents of a certain specified religion from immigrating to the United States. And there is evidence that that is still the purpose of this one, but it doesn't say that on its face. They purportedly have a secular purpose for the policy, which is a national security purpose, and the court has to decide what to do with that. Questions about that case? Yeah.
Because they're in national security, do you think that they're going to allow recordings? Do you think they're going to allow the case to be recorded in court?
Yeah, I mean, so the Supreme Court's audio of the Supreme Court's oral arguments is always recorded, and I'm not aware of any cases in which they've made an exception to that. And it usually is not released right away. It used to be they didn't release the audio till like the end of the term. So like at the end of June, they would release the audio for all the oral arguments for that whole year. Journalists have complained a lot about that. They've started releasing it, I think, like at the end of the week or whatever. And in this case, in fact, which they do have done sometimes, they say because of all the demand from journalists, we're going to release the audio recordings right away. So I think not live, they don't broadcast it live, but like immediately following the conclusion of the arguments, the audio will be released. In general, the court's oral arguments do not include any classified information, right? The arguments are open to the public. I'm trying to think if whether there's any been exceptions to that where they've closed, but there's like journalists present, there's public spectators present at the court's oral arguments. So there's national security arguments being made, but no classified information being shared. Yeah.
Is there any argument about the presidential power in this case?
There is. So there's multiple issues. If you look at the documents available on SCOTUS blog that list all the different documents in the case and stuff, I believe there's 4 different issues that the court, 4 different legal questions that the court has said it wants to try to decide in this case. And one of them is the religious freedom one I just talked about. One of them is basically about executive power. It's the way that they have framed it. It's not really a constitutional question about how broad are the president's powers. It's framed more narrowly than that. It's an immigration law question, but it's one that's been very controversial in recent years. So President Obama, for example, issued a number of executive orders regarding immigration policy. President Trump has done the same. Both of them did it because they have goals about what they think our immigration policy should look like, very different goals, but they both have goals about what our immigration policy should look like, and have had no success whatsoever in persuading Congress to pass any laws to reform our immigration policy. And so both Obama and Trump have argued that our existing immigration laws, right, so the existing federal statutes passed by Congress governing immigration, give a fair amount of leeway to the president to set the details of particular policies, right? He can't change the law, but he can issue regulations and executive orders within the terms of the existing law that fill in the gaps, right? So the existing law has some kind of line in it that says something like, for in the interest of national security or any other reasons that the president concludes, the president can temporarily order a halt to entry from certain categories of immigrants, right? There is some kind of line in there like that. And the question is Trump's pretty broad and sweeping executive order, which is not temporary, or at least does not appear to be temporary, does it fit within, like, is he allowed to do that by himself? Is that consistent with the existing immigration law, or is it not? And, a few years ago, there was conservative lawyers arguing that President Obama was trying to make up immigration laws on his own and do stuff that he's not allowed to do unilaterally, and now the tables are turned, right? And now it's liberal immigration rights advocates arguing that President Trump is doing that.
Doesn't the third version say that people from those 6 countries can come if they have relatives here, or can prove that they have a reason to come, like for education, for university? I think that was added in the third version.
I'm not sure about that. So I know with the second version, or maybe it was the third, with one of the versions, there was a dispute in court. So all of them have been challenged right away, and in all versions, courts have said, okay, while the legal challenge is proceeding, you can't enforce this policy because we think it's illegal or unconstitutional or violates certain people's rights, so we're putting a temporary injunction on it. So this is the third version. So the Supreme Court, when they agreed to hear the challenge to the third version, they removed that temporary injunction. They said, in the meantime, we're going to hear the challenge to it, but in the meantime, we think the government should be allowed to go ahead and enforce its policy. But they said they can't enforce it for certain categories of immigrants who have I forget exactly the language they use, but have a close family connection already with somebody in the United States, like somebody who would already be eligible to immigrate under these kinds of family connection rules. The administration should not be allowed to just blanket exclude them for now. So I think that just came from the courts. I don't think that's in the order. I'm not positive about that, but I don't think the order itself says Muslims from the Sudan, if they're related to somebody lawfully in the United States, can come. I'm not positive about that, but I don't. Anyway, we could look that up. Or we'll read the news tomorrow when they're talking about the oral arguments, and we'll see what they say about it. Immigration rules are complicated, and there's lots of different parts of immigration law, lots of different mechanisms under which people can lawfully enter and remain in the United States, right? Some of which have to do with family connections that you have to people already here, some of which have to do with just the luck of the draw, like there's lotteries, right? And there's a certain number of immigrants from your country are allowed each year, and you just your number gets picked. Some of which have to do with being sponsored by an employer, right? If you get a job in the United States, your employer can sponsor you to get an immigration visa. So there's lots of different categories, and the gist of President Trump's travel bans, at least in the early versions of them, and to some extent still in the later versions, is to just, for certain categories of immigrants from certain countries, to just cut all of those off, right? Whether you're a refugee, whether you're coming for family connections, whether you're coming for employment, whatever, if you are from one of these countries, you can't come. And the details are complicated. In the early version of the order, for some of those categories, President Trump's order was temporary. It had an expiration date. And for some of those categories, it was indefinite, right? So the details are complicated and are important. And we know that presidents have some leeway to set immigration policy on their own. But the question is how much, right? How much can they do unilaterally, or how much is it really only up to Congress to decide on that policy change? And that was a question under Obama as well as under Trump. And then we also know that even if the president has a lot of leeway to do things unilaterally, he can't blatantly violate the First Amendment, right? And so he can't just say, henceforward, the only people allowed to come to the United States are Christians, right? That would be clearly unconstitutional, right? And so, but that's not what this order says, right? And so the courts have to figure that out. There's also some complicated technical legal questions in the case about whether the state of Hawaii has standing to challenge the order, and whether the judge, this was a big issue under Obama too, over the past 10 years or so, there have been a number of high-profile cases in which the federal government has issued some controversial policy, somebody has challenged it in court, in a single federal district court, like located somewhere in the country, and that federal district judge has said the policy appears to be unconstitutional, I'm going to enjoin it, that means issue an injunction, preventing its enforcement nationwide. Right? The Supreme Court can for sure do that, but it is disputed among lawyers whether a single local federal district judge can do it, right? So like when Obama would issue an immigration policy, like the DACA executive order, Republican lawyers in the state of Texas, like the Solicitor General of the state of Texas, got in a car and drove 6 hours to like Brownsville or somewhere to file suit against Obama's executive order in a federal district court where there was only a single judge currently sitting, and they knew that he was very conservative. And so he heard the first challenge, and he issued a nationwide injunction, right? And if the policy is unconstitutional, then the government shouldn't be allowed to enforce it. But if only one judge has decided that it's unconstitutional, and he or she only has a small local jurisdiction, it is disputed among lawyers whether allowed. So a federal judge in Hawaii enjoined this policy nationwide, and that is another thing that's at issue in the case.
So in this case, how do they solve it?
Say that again?
In this case, how do they solve it with the Texan?
So far, if I understand correctly, this gets a little technical, but so there have been multiple examples. I'm sure there's probably some non-high-profile examples where it's happened too, but there are multiple high-profile examples, several of them about immigration law, where a federal judge has issued a nationwide injunction, and the Supreme Court, on a couple occasions, has vacated such an injunction, which is what they did in this case, right? They said the Supreme Court agrees to hear this case, Trump versus Hawaii, right? So they schedule it for oral argument, which is going to take some months away before they get to it, right? Supreme Court agrees to hear this case. They schedule it for oral argument. In the meantime, there's a temporary injunction in place that was imposed by the lower court, preventing the Trump administration from enforcing this policy. We are vacating that injunction. That injunction is no longer in force until the day on which we decide this case. The administration is free to enforce the policy. So the Supreme Court has done that a couple times, but they haven't decided the legal issue of whether a single federal judge is allowed to impose that kind of nationwide injunction. They might have decided it in the case involving President Obama's DACA order, but Scalia died before that case was decided, and the court was then split 4-4, and they couldn't decide the case. So that case never got decided. That was a case with many clear parallels to this case. Unilateral action by a president in the area of immigration policy to change policy in the opposite direction from this one, in this case to make some categories of immigration easier, not harder. But the court might well have decided some of these questions in that case, but it was split 4-4, and so it couldn't decide it. And so that issue never got resolved. So for a whole bunch of different reasons, this is a very high-profile case. There are a number of high-profile cases on the court's docket this year, some of them that we've talked about. This one, along with the gerrymandering case and the Masterpiece Cake Shop case and the like, and the union fees case. All these decisions are going to come down between now and the end of June, and so I encourage, even after our class is over, I encourage folks to keep an eye on these developments. So we're talking about religious freedom today, and I got two main questions for us to talk about, which are not directly the exact same question that the court is trying to decide in Trump versus Hawaii, but I do think they're related in some ways, right? Thinking through, the court has a long history of decisions, trying to think through what is the relationship under our Constitution between government and religious institutions. And the answer is complicated, right? It is hard to pin that down into a simple, clear-cut answer. And so the two questions for us to focus on today, which I think both help think through the Hawaii versus Trump issue a little bit. One question is, does the Establishment Clause prohibit all governmental endorsements of religion? This is something we talked a little bit about last week, but I want to look at it some more. Does the Establishment Clause prohibit all governmental endorsements of religion? And then the second question is whether the Free Exercise Clause prohibits neutral laws that incidentally burden someone's religion. Right? Neutral laws, not a law that expressly targets somebody's religion, but a neutral law that happens to have the effect of burdening somebody's religion. Is that unconstitutional or not? You can think of the difference between a law that says Muslims are not allowed to immigrate to the United States, or a law that says immigrants from the following countries are not allowed to immigrate to the United States, and all the countries on the list are, most of their people are Muslim, right? That one is more neutral. Or you could even think of a law that says, for national security reasons, all of the following countries, immigrants are not allowed to enter the United States, and most of the countries are majority Muslim on that list, but not all of them, right? It's not expressly targeting anybody's religion, but it might be having a significant burden on the practice of somebody's religion. So take the endorsement question first. So there's a whole bunch of different relevant cases here. We talked about some of these cases last week, right? So like the school prayer issue in Lee versus Weissman that we talked about last week, which is about prayer at a public school graduation ceremony, right? They invited a rabbi to deliver an invocation at the beginning of the ceremony. In previous years, they had sometimes invited a local Christian pastor. This year, they invited a rabbi. Justice Scalia's answer is no, this does not violate the First Amendment, right? Nobody is coerced into doing anything, right? Nobody is forced to recite a prayer, right? As long as there is no coercion, there is no problem, right? He got outvoted in that case. Scalia was in dissent in Lee versus Weissman. And he got outvoted for kind of two different reasons, right? Some of his colleagues said, actually, we think there was coercion present. Right? Justice Kennedy wrote about peer pressure for school-age kids. Right? If everybody else, right, if it's a majority Christian school and there's a couple Jews and atheists or whatever, or a couple Buddhists or Muslims or whoever, right, and everybody else is standing up and participating in the religious exercise, you might feel some significant pressure to do so yourself, even if you don't share those religious beliefs. And those subtle forms of coercion count, Justice Kennedy said. Right? So he disagrees with Scalia. Scalia said there's no coercion here, so it's not a violation of the First Amendment. Kennedy says, oh, actually, in fact, I think there was coercion here, or at least potential for coercion. Some of the justices disagreed with Scalia because they didn't think coercion is all that's prohibited. Yeah, coercion is prohibited, they agree with that, but there are other things that are prohibited too, and one of the other things that is prohibited is endorsement. Even if nobody is coerced to do anything, the First Amendment still prohibits governmental endorsements of religion. If you think about the case about the holiday display, right, at Christmas time, right, a local city council puts out a Christmas tree and a sign that says Merry Christmas and a nativity scene, right, a creche, a depiction of the birth of the baby Jesus. That display does not coerce anybody to do anything, right? But some justices believe it is nonetheless unconstitutional because it signals a clear governmental endorsement of a particular set of religious beliefs. Justice O'Connor made this kind of argument all the time. Sandra Day O'Connor, Justice Stevens, John Paul Stevens made this kind of argument all the time. Coercion is bad. Coercion is prohibited. We don't want anybody coerced to participate or not participate in religious exercises. But that's not the only thing that's bad. Right? Even if there is no coercion, if the government is endorsing a particular set of religious beliefs, that violates the First Amendment. So that view was in the majority in Lee versus Weissman. But more recently, the court decided a case called Town of Greece versus Galloway in 2014, which involved a practice, this is from New York, right? Greece is like a suburb of Rochester somewhere, right? Yeah. Small town, in suburban Rochester, that had a long-standing practice of opening their monthly city council meetings with a prayer led by a local religious leader. Turns out they had somebody on staff at the city council who would open up the yellow pages and like flip through the religious listings in the yellow pages. Do people even know what yellow pages are anymore? Right, an old-fashioned phone book. They would open up an old-fashioned phone book and flip to the listings of churches, and they would pick one, and they would call the church and be like, "You want to come deliver a prayer at the city council meeting this month?" And prior to the filing of the lawsuit, the only people they had ever invited were Christian pastors. They said in court that they were open to inviting any kind of religious leader, but again, prior to the filing of the lawsuit, the only people they had actually ever invited were Christian pastors. And somebody challenged it as unconstitutional and made its way to the Supreme Court and lost. And the Supreme Court said this was okay. Basically, one way to think about it from the court's perspective is this more like school prayer, like prayer at a high school graduation ceremony, public school graduation ceremony? Or is it more like the holiday display on the town lawn, or the legislative chaplain that's on staff in Congress or in a state legislature? Because the court has struck down school prayer and the court has upheld holiday displays and legislative chaplains, courts seem to say this is more like the latter, right? Nobody is coerced to do anything, right? So it doesn't violate the Establishment Clause, right? City council meetings, the business of city council meetings is to conduct public business, right? They pass laws to govern the town. They also they have like kind of administrative and like regulatory functions. Like if you need like a permit to do something, right, you can show up at the town council meeting and plead your case and request the permit. The court said, yeah, anybody who's there to conduct whatever kind of business they want, they're not forced to participate in the prayer. That's just a brief thing at the beginning to thank God for blessing us, and then we're going to go about with our regular business. Nobody is coerced to do anything. The dissenters are like, maybe we aren't 100% convinced that nobody is coerced to do anything. It's not, we're not talking about school-age kids, so maybe that's a relevant difference, right? Maybe there's less peer pressure for full-fledged grown-ups than there is for teenagers. But nonetheless, think about this. You are in a predominantly Christian town. You show up at the local city council because you're requesting a variance, to like expand the parking lot at your store in downtown or whatever, and you are Jewish or Muslim or atheist, right? And everybody else is like standing up and participating in this prayer, and you're there to conduct business, to request them to approve something that you need approved. You might feel some subtle pressure to go along with what everybody else is doing and to participate in the religious observance, even if you don't believe it. Maybe. That's what the dissenters said. And they also said, even if there is no coercion, it might still be unconstitutional, because it seems to be conveying a clear governmental endorsement of a particular set of religious beliefs. Even if we agree with you that nobody is coerced to do anything, we still think that is unconstitutional, because it is an express governmental endorsement of religion.
Because the town hall is like an essential part of like the government process and the ability for citizens to seek redress and whatnot, why is not the mere attendance considered coercion? You're coerced to attend because if you don't attend, you cannot carry out the legally obligated or allowed things.
Yeah, I guess the way Scalia would say it is you're there to conduct some business, right? But the brief religious observance at the beginning of the meeting, you can just sit respectfully in your seat. Nobody's making you do anything, right? It's not, you could think of it as I want a permit to expand my parking lot. I'm being compelled to attend a religious ceremony before I do it. But it's not really a religious ceremony. It's a city council meeting with one very brief prayer at the beginning of it, right? This is what Scalia says in the public school graduation case. He's like, come on. Just sit there respectfully. How big a deal is it? Right? Just sit there. You don't have to do anything. You don't got to say the prayer. Right? That's Scalia's view. Right? And if you're only focused on coercion, that view makes some sense. You could still have some arguments about, well, whether there is some degree of coercion there, subtle coercion. But if you're only focused on coercion, that view of the situation does make some sense. But if you believe that governmental endorsements of religion are also constitutionally problematic, that view just doesn't make any sense at all, right? Because whether or not you're compelled to stand up and recite the prayer, which obviously nobody is making anybody do that, right? If the government, if at a clearly governmental event, right, a public school graduation ceremony is a clearly governmental event, a city council meeting is a clearly governmental event, right? If that governmental event, the government officials are leading people or inviting somebody to lead people in a Christian prayer, it seems to suggest that government is endorsing some particular set of religious beliefs. And so what O'Connor would always say is the problem with this is that it is signaling, it is sending a message to certain members of that community that they are not really full members of that community. Right? If you are the Jew or the atheist or the Buddhist who's there to get your permit to expand your parking lot, you're getting the message that you're not really a full and equal member of this community. Right? And that at a governmental function, like a public school ceremony or a city council meeting, the First Amendment doesn't allow that. Right? And so if you think about this kind of question of endorsement, government endorsements of religion, it comes up in all different kinds of contexts. There was a case in 2004 about the Pledge of Allegiance in public schools, which of course includes the phrase "one nation under God," right? So it's not a primarily religious, right? The Pledge of Allegiance is mostly a patriotic pledge, but it does say "one nation under God." That part was added in the 1950s under President Eisenhower. It didn't say under God before that. But it does say under God, right? And some people don't want to say that because that is not their religious beliefs. And in a case called Elk Grove versus Newdow in 2004, the court basically ducked the issue. They refused to decide whether reciting the Pledge of Allegiance in public schools is constitutional or not. But Justice O'Connor wrote an opinion, and she said, well, we're going to have to decide this at some point. And the key issue here is, do we think that the government is conveying a message of endorsement of certain Christian religious beliefs when it leads students in a public school in reciting the Pledge of Allegiance? And if that is what's happening, then that's going to violate the First Amendment. It comes up in cases involving public religious displays, right? So the annual holiday display, so the court said was okay in the 1980s, but if you read that case, the court emphasizes, well, it's not really that religious. Come on, Christmas, that's like Christmas isn't that religious. It's about the holiday spirit and like taking a break from work and spending time with family and giving presents to each other. That's the main point of the holiday display. And look, sometimes they even like stick a menorah in the display or something too, right? It's not endorsement of any particular set of religious beliefs. It's more got a secular kind of cast to it. That's what the court seemed to say in that case from the 80s. But there are, of course, governmental religious displays that appear to be much like, for sure, seem pretty indisputably religious, right? For example, if a government building is displaying the Ten Commandments, right? If you walk into a public school classroom, or if you walk into a courthouse, right? You walk into a courtroom to appear as a witness or a defendant or whatever in a civil or criminal trial, and the judge in the courtroom has prominently displayed the Ten Commandments, or the judge has placed on the lawn outside the courthouse like a gigantic granite display, huge, big, imposing display of the Ten Commandments, that seems pretty religious. Right? That seems like a pretty clear governmental endorsement of certain sets of religious beliefs. There's multiple different versions of the Ten Commandments, depending upon which version of the Bible you use. But at least some of them include a passage that goes something like this. Thou shalt have no other gods before me, right? Isn't that how it starts? Something like that. It's not just like thou shalt not kill, thou shalt not steal, right? Those are the actual specific rules, but the preface to it, the part at the beginning, is a very clear statement of monotheistic belief in a Christian God. There are obviously lots of Americans who do not share those beliefs, right? So in two cases in 2005, the court had to decide whether these public displays of the Ten Commandments were unconstitutional or not. Two different cases they decided on the same day. They have a little bit of a habit of doing this. Remember the Michigan affirmative action cases? One case about undergraduate admissions, one case about law school admissions, both decided on the same day. The court upheld one of the policies and struck the other one down, and it's a way for them to kind of... So here in two different cases that are about the same issue but with slightly different facts, they hear them at the same time, gives them some opportunity to kind of split the difference. Well, we can see some arguments on both sides, so this kind of affirmative action is not allowed, but this kind is okay. They did the same thing here. They said one of these Ten Commandments displays violated the First Amendment, and the other one didn't. Right? And the gist of it was, the details are complicated, but the gist of it was, in one of the cases, it was a recently erected display that, I think it was like on the lawn of the state capitol building, that the state legislature had voted just recently to erect, and there was crystal clear evidence from the legislative history that the state legislators were attempting to endorse some particular set of religious beliefs, right? That national controversy had emerged. There was a guy named Roy Moore who ran for Senate last year, who was a judge in Mississippi at the time, and he had gotten national headlines for putting the Ten Commandments out in front of his courtroom and then refusing to remove them when a federal court ordered him to remove them. So it was national controversy, and then the state legislature was like, all right, yeah, well, we believe in the Ten Commandments. We think we should be allowed to display them. And if you followed the legislative history, they were expressly endorsing like Christian beliefs and saying, we want government to be endorsing these Christian beliefs, right? That's unconstitutional, Supreme Court says. Blatant effort to signal governmental endorsement of one particular contested set of religious beliefs. The other display had been there for like 50 years or something. It was in Texas. It was in a public park. There was the Ten Commandments in the public park, but there was a bunch of other different kinds of statues and historical monuments and markers as well. I don't remember, something about the Alamo or something. There were multiple monuments, statues, historical markers of various kinds in the park, including the Ten Commandments. And the court was like, all right, well, that's a little different. Right? They set it up 50 years ago. They didn't, we don't even know if we have good evidence about what they were thinking back then when they set it up. They didn't just set it up last week because they liked what Roy Moore was doing and they were trying to express support for it. Right? It's been there for a long time, apparently without very much controversy in the local community. It is not a single solitary Ten Commandments monument. It is one monument placed among a whole bunch of others, like when the court emphasized that the creche was surrounded by a Christmas tree and a bunch of other secular kind of images. The Supreme Court says that one's okay, that one does not. Neither one of them coerces anybody, right? No monument erected by the government coerces anybody to do anything. But the first monument is such a clear, blatant, and explicit endorsement of one particular set of religious beliefs that it violates the First Amendment. The second monument does not seem to send that same message, we think. and that one's okay. Questions so far? One of the things to think about in these cases is if the government has some leeway to publicly, I'm trying to use a word other than endorse, right? To publicly acknowledge and express some set of religious statements and ideas, right? Like at the opening of a city council meeting, the government should have some leeway, right? If that's true, then are they required to actually make that space open to adherents of all religions? Because if you think about Greece versus Galloway, right, the small town city council meeting, they said in court, oh yeah, we'll let anybody do this. We've only ever invited Christian pastors so far. I guess that was an oversight. Most of the religious institutions in our phone book are Christian, but anybody's welcome. If anybody wants to send us an email, we'll add them to the list. But it is an open question, like when the rabbis and the imams start calling that city council and saying they want to deliver the blessing too, we will see whether that city council really means it and whether they are really open to letting a wide variety of religious leaders issue these prayers at the meetings. A sort of similar thing comes up in the Ten Commandments context. Right, so those first decisions were in 2004, where it upheld one display and struck the other one down. A few years later, another case comes to the court. It's called Pleasant Grove City versus Summum in 2009. There is a public park with a Ten Commandments display that had been there since 1971. It had been donated by a private organization to the local city government, and they had put it up in a public park. There's some other stuff in the public park too. There's a 9/11 monument. There's some historical marker about the city's first fire station. There's some other, so like in the Texas park, it's not just the Ten Commandments. There's a few different things in the park. And there's a church called the Summum Church that wanted to donate a monument reflecting their beliefs as well, right? They read in the paper that, the Fraternal Order of Eagles had donated the Ten Commandments monument back in 1971, and the city had erected it in the park. Okay, we want to erect a monument reflecting our religious beliefs too. The Summum Church is a quirky religion. I don't know very much about it. You can Google it. They have something called the 7 Aphorisms of Summum, which is what they wanted to list on their monument. If you are not a practitioner of this religion, Google it, and they are going to seem a little weird, right? But the church said we want to donate it, right? We got the Ten Commandments up in the park. We want our religious monument up in the park too. No cost to the city. We're going to donate it. City says no. We don't want to display that crazy thing in the park. We're not listing those things on a monument in the park. Are you crazy? No way. We're not doing that. And the Summum Church goes to court. And they make their way to the Supreme Court. And they lose. And the Supreme Court's like, yeah, we have said a few years ago that the city governments in some circumstances can display the Ten Commandments. And even if they do so, they are not required to display similar monuments requested by all other religions. And now this is starting to raise some eyebrows. Like, it's one thing to say, oh yeah, it's in the public park, it's surrounded by other monuments, that doesn't really convey any clear governmental endorsement of religion. No, that's not how people are going to read that. You're walking through the public park and you see the 9/11 memorial and then you see the Ten Commandments memorial, or monument or whatever, and you're not going to think the government's endorsing Christianity there. But if they are expressly saying yes to some churches and no to other churches, then it's starting to look like government is favoring certain religions and disfavoring others, which is one of the reasons why some justices from the beginning said we should not allow any governmental endorsements of religion. Because if government is allowed to endorse religion, one of the things that's going to happen is all of the churches around are going to start lobbying for the government to endorse their religion. Right? Why you got government endorsing some churches but not others? Right? We got different religious ideas. We want government to endorse ours too. And that is unseemly. Right? We do not want churches competing for governmental support. One of the points of the separation of church and state is to prevent that. But Supreme Court says the city's okay here, and it's again one of these cases where they don't really quite directly answer the main question. Right? The main question is, some church thought the main question was, does it violate the Establishment Clause if the city puts a Christian monument in the public park and refuses our request to put a summum monument in there too? Right? That's what they thought the main question was. The court doesn't really directly address that question, although some of the justices, including Scalia, Thomas, and Alito, wrote an opinion in which they seem to say, yes, that's fine. The city can, we're not quite answering this question directly today, but if another case comes back to us, our answer would be that yes, it is okay for the city to place a Ten Commandments monument in the public park and not the 7 aphorisms of summum. Another case, the following year, raises a really similar set of issues. This one's called Salazar versus Buono in 2010. This one had a long history. In 1934, a group of private citizens placed a Latin cross on a rock outcropping in a remote section of the Mojave Desert. Their purpose and intent was to honor American soldiers who fell in World War I. Right? A single Latin cross erected in the desert to honor fallen veterans from World War I. The original cross deteriorated over time, and supporters had rebuilt and replaced it several times. The most recent version of it was 8 feet tall. It's on federal land in the middle of a national park. Right? A solitary 8-foot-high Latin cross. A National Park Service employee filed suit. He said that he was not Christian, and he was offended by the cross's prominent display on public property. The local federal district court held that the clear effect of the display was to create an impression that the government was endorsing a particular religion, and the court ordered it removed. Meanwhile, Congress passed 4 different laws trying to prevent the removal of the cross. In 2001, this was actually before the suit was filed, but people had started calling attention to it and complaining about it. Congress passed an appropriations bill that included a provision forbidding the use of government funds to remove the cross. Right? No federal government funds may be used to remove this cross from this national park. In 2002, while the case was pending in district court, Congress designated the cross and its adjoining land as a national memorial commemorating U.S. participation in World War I and honoring the American veterans of that war. Right? It's the middle of a national park in the Mojave Desert, but this particular tiny little plot on which the cross is placed, Congress has designated as a World War I memorial. Why'd they do that?
Historical landmarks can't be removed.
Yeah, well, I mean, they can be removed, right? We can decide to get rid of a statue of a Confederate general, right, if we want. So not that it can't be removed.
I guess it changes what the cross ostensibly represents, you know, if it has some sort of justification beyond religion that the federal government says is its true reason for being there, then it's hard for the courts to then say, no, the government's reason is, like, false.
Congress says it's not a religious marker. It's a World War I veterans memorial. right? They didn't change anything about the cross or the land on which it was erected. They just passed a law that said, this is a World War I Veterans Memorial. It's an effort to give a secular purpose to the display, right? In 2003, Congress again prohibited the spending of governmental funds to remove the cross. By this time, the district court had ordered it removed, right? Violates the First Amendment, you got to remove it. But then Congress passed a law, so you're not allowed to use any federal funds to remove it. So National Park Service employees erected a plywood box and put it over the cross because they were not allowed to remove it, but they had been ordered to remove it. They're like, what are we supposed to do? So they put a box over it. And in 2004, while the government's appeal was pending, Congress passed a land transfer statute directing the Secretary of the Interior to transfer to the Veterans of Foreign Wars, which is a private organization representing veterans, transfer to the VFW the government's interest in the land that had been designated the National Memorial. And in exchange, the government was to receive land elsewhere in the preserve from Henry Sandos, a private landowner. Right? So the government made a deal with somebody who owns some nearby land. So no money is being exchanged. Right? The government will donate this tiny plot of land to the VFW, and in exchange, this guy who owns some land nearby will give an equally sized part of land to the government. So the national park is staying the same size, but this is no longer public property, according to Congress. And by the time it gets to the Supreme Court, it's that last step by Congress that is at issue. Right? We got a single solitary 8-foot-tall Latin cross erected in the middle of a national park, but Congress now says it's not really in the national park. It's on privately owned land, surrounded by national park, but the cross itself is not on public property. Does that violate the Establishment Clause? And the court says no. And again, they don't really directly answer the main question. They are really struggling with this, right? In either of these cases, Summum Church or Salazar versus Buono, the court could have directly answered the question. If we say that under the First Amendment, the government is allowed to have some kind of religious display, right? Are they also allowed to exclude other religious displays? Right? One of the issues that had come up in the park is that the Park Service employee who had first filed the case, he was a Buddhist, and he said, I want you guys to take down this cross, but in addition, if you're not going to do that, I want to erect a small Buddhist shrine nearby. And they said no. Right? So, not only are they displaying something that belongs to one religion, they are saying no to the Buddhist shrine and the 7 aphorisms of Summum. Right? They are saying no to displays that belong to another religion. Some of the justices who have been saying, in case after case, oh yeah, the government should be allowed to do religious displays as long as they're not coercing anybody to do anything. The government should be allowed to do religious displays. Some of those justices seem like they have not quite been ready to say, yeah, and that also means they can pick and choose. They can say no to other religions. That seems like the kind of logical next step, right? The public park really going to have to display something from every religion that requests it? That's going to get complicated. But if you say the city government can display religious markers from some churches but not others, that does not sound right either, right? And so the justices have ducked that issue in these two cases. And the dissenting justices in Salazar versus Buono are like, this is precisely why we should not allow the government to display clearly sectarian messages. Justice Stevens wrote a dissenting opinion in Salazar versus Buono. Stevens was a World War II veteran. And there was actually a super interesting exchange at oral arguments in the case. The lawyers who were challenging the Latin cross said that a Latin cross displays a indisputably sectarian message. And Justice Scalia at oral arguments said, no, it doesn't. I don't believe that. Why is that sectarian? He's like, look at the cemetery in Normandy. Have you ever seen the famous images of just a huge field of white crosses marking the graves of fallen Allied soldiers from the D-Day invasion in Normandy, France. He's like, have you ever seen those photos of Normandy, right? The thousands of white crosses? Like, that honors all fallen veterans. Like, that's not a sectarian message. And the lawyer was like, I have seen those photos. I have been to Normandy, and there are Jewish soldiers buried in that cemetery, and their graves are marked with a white Star of David. They are not marked with a Latin cross. And if you Google image it, you will see. You got to look close. You'll see like hundreds of white crosses, and then you'll see a white Star of David in there. Right? It's like, that white cross does not honor everybody. Right? Not everybody worships that cross. Right? So that was at oral arguments. Justice Stevens, who was the World War II veteran, wrote in his dissenting opinion, a solitary Latin cross conveys an indisputably sectarian message, and the government should not be allowed to display it on public property. And the mere fact of calling it a war memorial, or saying that these 10 square feet of land are no longer public property, even though it's still in the middle of a public park, neither of those things makes the clear sectarian message go away. Right? Government should not be allowed to do it. It's too clear and explicit of an endorsement of one particular set of religious beliefs. But he was in dissent.
So, was this a 5-4 decision?
It was, yeah. So Salazar versus Buono was, so both of these, they kind of ducked the main issue. In the one about the summum, 7 aphorisms of summum, they said, well, the real issue in this case is not about, the real issue in this case is just about government speech. Like, even though the monuments were donated by private organizations, it's not about the government turning away. It's not about the government saying you're not allowed to practice your religion in our community, or you're not allowed to have a rally in the park. Right? It's the government's own speech, and the government can say whatever it wants. Right? If the government puts up a climate change sign, it doesn't have to put up an anti-climate change sign too. Right? The government's own speech, they can say whatever they want. That's what they say in the summum case, and in Salazar versus Buono case, they say that the dude who challenged it, the Park Service employee, did not have standing to challenge the case, which seemed to be an effort to duck the main issue, right? Why doesn't he have standing? He had to look at that thing every day, right? It's on public property, or at least it was on public property. Anyway, they ducked the main issue in both those cases, and the summum was not closely divided, but Salazar versus Buono was 5-4. If you think again about Greece versus Galloway, the city council case, right? So this now, what I'm about to say is a made-up case that doesn't exist yet, but it could come, right? City council invites the local Christian pastors to deliver the prayers. Somebody challenges it. They go to the Supreme Court and they lose. The Supreme Court rules in favor of the city council and says, you can keep doing this. But now that there's more attention on it, I would not be surprised if a variety of local religious figures in the town of Greece, right, have requested to participate. And I would also not be surprised if eventually a religious figure gets turned down, right? You could imagine some communities saying no to the local imam, right? You could also imagine some communities saying yes to all the Christian pastors and rabbis and imams, but then, like the dude from the Summum Church calls, or like the Satanist calls, right? Why are they not allowed to deliver an invocation? I'm pretty sure the city council does not want to open its meetings with an invocation from a Satanist, right? But what is the constitutional argument that they are allowed to invite Christian pastors to open their meetings with a prayer, and they are also allowed to say no to the religions that they think are weird or unacceptable? Like, what does that argument look like? That's going to be a hard one. So that case hasn't happened yet, but it is, all of these cases have been sort of leading in this direction. Like, the current court has in some contexts allowed some degree of governmental endorsements of religion. City council prayers are okay, one of the 10 Commandments displays is okay, but that then leads to this next round of questions about like who are you picking and choosing, right? Which religions is the government endorsing and which ones is it saying no to? All right, so the next question I wanted to talk about, at least briefly, is goes back to something that we talked about during the Warren Court era. Remember the case of Wisconsin versus Yoder, which is actually like 1971 or something, so not quite Warren Court. There was an Amish community in Wisconsin that objected to the state's compulsory education laws. Right, the laws on the books in Wisconsin at the time said you have to attend formal schooling until age 16. You can go to public school, you can go to private school. Homeschooling wasn't that big back then, so there weren't many provisions in state law addressing it. You got to go to some kind of formal schooling until age 16 for obvious secular purposes, that we want an educated citizenry and workforce and the like in the state of Wisconsin. And in the Amish community, the practice was to send kids to school for a few years to learn to read and write, basic arithmetic, and then they would just come back and work on the farm. Right? No more formal schooling was necessary, and in fact, they did not believe in it. Right? They believed that the tenets of their whole cultural, religious belief system, the kids, after they learn to read and write, should be working on the farm with everybody else. And the Amish said this law was unconstitutional, violated their free exercise of religion, and they won in the Supreme Court. The law obviously was not passed to discriminate against the Amish. It does not say anything about the Amish. Nobody was thinking about the Amish when they wrote it. It had a completely secular purpose. But it happened to have the effect of burdening the religious practices of this particular group. Similar case from the Warren Court era was Sherbert versus Werner, which was a Seventh-day Adventist who got fired from her job for refusing to work on her Sabbath, and then got denied unemployment insurance by the state government because she had been fired for cause. Unemployment insurance is if you lose your job through no fault of your own, then the government's going to temporarily give you a bit of a stipend to tide you over until you find a new job. But if you refuse to show up for work, then you don't get unemployment insurance, right? That was your fault for getting fired. That unemployment insurance rule does not discriminate against Seventh-day Adventists. It doesn't say anything about Seventh-day Adventists. It doesn't say anything about religion at all. Nobody was thinking about religion when they wrote it. It says if you get fired for cause, if it is your own fault that you lost your job, you don't get unemployment insurance. It doesn't say anything about religion one way or the other. It's perfectly neutral. But the court says if it happens to have the effect of imposing a substantial burden on somebody's practice of her religion, it violates the First Amendment. The court basically reverses both of those decisions in 1990. It does not say that it's reversing them, but it basically reverses them. Sometimes the court explicitly says it's overturning a precedent. Bowers versus Hardwick was wrong, and we overturn it today in Lawrence versus Texas. Sometimes they don't say that. Sometimes they even deny that they are reversing a precedent, but that they are clearly deciding the issue in a different way. And that's what happens in 1990. The case involves some Native Americans in Oregon who ingested peyote as part of a Native American religious ceremony. Peyote is a hallucinogenic, naturally occurring hallucinogenic substance. They ingested peyote in a religious ceremony and then failed a drug test, failed a mandatory drug test at work, tested positive for peyote, and were fired. And in fact, one of the dudes who got fired was a drug counselor, which is why he was being drug tested. I don't think he was mostly counseling people for how to deal with peyote abuse, but he was a drug counselor, and he failed the mandatory drug test, and he got fired from his job, and then he got denied unemployment insurance, right? Because if your employer fires you for failing a mandatory drug test, that's your fault, and you don't get unemployment insurance. And he made his way to the Supreme Court. And under Sherbert versus Werner, which is basically like the exact same case, basically, it seems like he should for sure win. And he lost. And Justice Scalia wrote the court's opinion, and it's one, at least among constitutional scholars, it's not like a big famous opinion like Bush versus Gore or Roe versus Wade or something, but among constitutional scholars, this is one of Scalia's most famous opinions. Scalia says, like, the opposite of Sherbert versus Werner. He says, if a law is neutral and generally applicable, nobody cares if it happens to burden your religious practice. The First Amendment is about preventing the government from intentionally singling out and targeting members of some particular religions. If the government passed a law that said Seventh-day Adventists are not eligible for unemployment insurance, we'd strike that down in a minute. But they didn't do that. The government is not discriminating against anybody's religion. It's a perfectly neutral, generally applicable law that merely happens to have the effect of burdening somebody's religion. That does not violate the Constitution. It is like the murder laws, which happen to have the effect of burdening the practice of your religion if your religion compels you to engage in human sacrifice. But nobody enacted the murder laws because they were trying to single out your religion for disfavored treatment. It is a neutral, generally applicable law that just happens to have that effect. Justice Scalia says. Got a hand?
Okay, so did he actually mention human sacrifice?
He did.
Okay, isn't that a little hyperbolic?
Yes.
Because I think there's a difference between...
Scalia, in gay rights cases, Scalia was famous for talking about, like, bestiality and stuff. Like, his rhetoric is sometimes a little bit over the top. It's snappy, makes for good reading. Scalia, in fact, used to even say sometimes, I heard him say that when he was writing his opinions, the audience he had in mind was law students, right? Especially with dissenting opinions, right? Because law students is the whole next generation of lawyers, right? I want them reading my opinions and learning my view of the Constitution. And the way you got to get law students to read your opinions, you got to get your opinions into the case books, right? Not every case is in the case book, right? And the ones that are in there, they don't even include every opinion. They edit them down for length, you know? He's like, I want my opinions in there, so I'm making them snappy, right? And so his rhetoric was sometimes over the top. That's a pretty extreme analogy, for sure. That does not seem all that... I mean, you can see the logic of it, but it does not seem all that helpful in deciding what kinds of burdens on religious freedom are allowed and what kinds aren't. In dissent, Justice O'Connor pointed out that one of the results of Scalia's approach was likely to be more governmental discrimination against minority religions. Because if you think about it for a second, if the government, say in a local community, a town that's majority Christian or a state that's majority Christian, if they write a neutral law that's not really about religion, but it happens to impose some substantial burden on the practice of Christianity, they would probably notice and do something about it, and they would change that law. For example, when most states in the country, well, for a while, the whole country, but even before then, many states in the country enacted prohibition laws, right? Laws banning the sale of intoxicating beverages. Every single one of those laws made an exemption for the sacramental use of wine, right? The Catholic Church can still buy some wine to use in its religious ceremonies, right? Every single one of those laws, right? Because obviously they're aware of that impact. The prohibition law doesn't target anybody's religion, but if you say nobody's allowed to buy alcohol, that has the incidental effect of making it hard for Catholics to practice their religion, right? So they made an exemption. But if your law happens to incidentally burden the religious practice of some smaller minority religion, there is no guarantee that the majority is going to notice or care. And I thought, Justice O'Connor said, one of the points of having an independent Supreme Court with unelected justices who can enforce the Bill of Rights is to protect the rights of minorities. Justice Scalia is refusing to do that here. Native Americans are a minority in the state of Oregon, and it is just one particular group of Native Americans who are members of this particular church who practiced the sacramental ingestion of peyote, the government didn't notice that the way it wrote its unemployment laws was going to have the effect of burdening people's exercise of this religion. Right? Normal religions, majority religions, the ones they were focused on, the ones they were familiar with, don't involve the ingestion of illegal drugs. Right? They weren't thinking about it. If we say that the Constitution does not impose any limits on a law that substantially burdens religious practice, as long as the law on its face is neutral, the people who are going to bear the brunt of that are members of religious minorities. Justice O'Connor says in dissent. One of the reasons this case is famous is the court has never reversed it. It was in 1990, and the court has not reversed it. But, like, everybody hated it. Like, everybody was mad about it. Among, like, normal people, if you ask them about it, like, everybody disagrees with it. Among members of Congress, if you ask them about it, everybody disagreed with it. Congress passed a law attempting to reverse this decision, and it passed something like 430 to 3 in the House. Right? Everybody, I don't know who the 3 people were who voted against it. Basically everybody on the left and the right, Congress was not quite as polarized back then, but still, everybody voted for it because, like, the Christian Coalition, right, religious conservatives, they're like, we don't like this, right? The ACLU was like, we don't like this, right? We think that one of the purposes of the free exercise of religion clause, we think one of the purposes of that clause is to protect the rights of members of minority religions to fully and freely engage in their religion, as much as is practicable without, like, directly harming somebody else. Right? We think the First Amendment should protect that. So Congress tried to reverse this decision of the Supreme Court, which Congress is not really allowed to do. Right? And the Supreme Court struck down that law that Congress was using to try to reverse the decision, because they're like, well, dudes, you can't reverse our decisions, right? We're interpreting the Constitution. Congress has since passed some subsequent laws that still try to limit the reach of the decision, and so there's some things that Congress is allowed to do, like if we're talking about the operations of the federal government, like, for example, a federal prison, right? Still the Supreme Court's job to decide what the First Amendment requires, but Congress can pass whatever laws that it wants to try to govern the operations of federal prisons, as long as they're not violating the Constitution. And Congress says, for federal prisons, any policy that they adopt, if it substantially burdens somebody's practice of their religion in prison, even if the policy is perfectly neutral, right? The government cannot impose that policy unless they carve out an exemption for members of that religion or demonstrate a very strong, security justification for the policy, right? So if you pass a law that says everybody has to have short-cut hair, right? That is neutral. But if that substantially burdens somebody's religious practice in prison because their religion commands them to have dreadlocks or whatever it is, you can't enforce it on them, right? Even though the Supreme Court said you could, we're saying you can't, right? For whatever parts of the operation of the federal government we're still in control of, we are trying to go in a different direction than the Supreme Court is going in that peyote case. That's all.